Right. Take it too, Black. Now, I heard somebody said something about a bailiff. Now they saw a television programming set where there was a big fat pot-bellied man, two of them, and they went to someone's house and say that if you don't pay it, we'll take it. And they say that they're bailiff, and this was on television apparently. So someone was afraid that these two men might show up in their house. And I'm trying to explain that, no, that's television. It's for entertainment. It's not real. No one's going to show up in your house just like that out of the blue. So this is for bailiffs. So anyone who wants to deal with bailiffs. Years ago, in another lifetime, when I used to deal with bailiffs, it seems to be the same guy. So this is the one who runs, I hope we can get this thing closer. That's the guy who runs it. So, so if you get mail or offers from, is it Rosendale's, Jacobs, Marston's, it's the same company, it's a holdings company. Well, they have a branch where they call themselves bailiffs. Right, so this is for bailiffs. This is for the legal fiction business, ladies and gentlemen. We all know about the legal fiction now. So this is for legal fiction business. This is for the actors and the acting. Right? In any case, this is how you draft your claims against this bailiff. Alright? Now in any case, the bailiff doesn't just show up. He just doesn't show up and say, we're going to take your property. Because first of all, they're going to write to you. And you're going to write you once, you're going to ignore them. They're going to write you twice, you ignore them. They write you 3 times, you ignore them. Someone's going to come and drop a card through your post. You're going to ignore that. They're going to give you a final demand and let you know when they're going to come and what time. You can ignore that as well. And then they're going to show up. And then you start screaming and shouting and getting emotional and acting like a little bitch, and you've ignored this process. So don't ignore it. If you're going to ignore it, then you have to ignore it totally, completely, so that you have plausible deniability. But you cannot go in and out or step in and out. So either you're the debtor or you're not the debtor. So you need to know your position. Are you the debtor or are you the creditor? Right, so when they write you, they're going to have the reference numbers. So when you draft your claim, you put it in there. So reference numbers, whatever numbers you get on the forms, and then you're going to put your name as applicant, APP. In syntaxing, APP is a non-contracting word, but in the legal fiction world, it does operate. So you use yourself as an applicant, they're the respondent, so you're going to write to him directly. The purpose for this document is that you prepare the document that you're going to use in court in the same format that you're going to use in court, so you don't need to change the format. So you draft the claim and write it exactly as you would file it in court, but give it to him first of all. So if he doesn't respond, the same claim is the one you file in court with a few additions here and there if necessary, and you make your life easy. So boom. So it begins like that. It's applicant, get them to be the respondent, get this thing right. Let's go back. like dig that. I hope you can see that. Alright, so we're going to go in. So this is going to be a pre-action notice of complaint, as it's called in the legal fiction world. In the real world, you draft claims, right? So this word would be a claim. If a man or a woman was drafting it, it would be a claim. However, because this is in the legal fiction world, and you're drafting this in capacity of your legal fiction, so you're doing business in the legal fiction world where they have pre-action things. Action. An action is an act. So before I start acting, I'm going to give you notice how I'm going to act. Alright? So this is so I'm going to complain like this. So this is for I. You put your appellation there. The camera right. Here we go. Right. So put your appellation there. You put your location there. Right. Now in this business of estates, you can state something. So you do state and say as such. So here you need to set out the nature of your complaint. If it's a living man or woman, it's going to be a claim. As a person aggrieved by an injustice done to me by, you put their name there. Now, this is legalese, by the way. Okay? And for those who understand language, I won't go through the whole document. I'm just going to do the first paragraph, number 1. But I won't do the rest of it because it's going to take me all day to break this down. So I'm just going to do the first paragraph. The rest I'm going to presume that we understand each other and we just carry on. So I set out the nature of my notice of complaint as a person, number 1. We all know a person is a corporation. Aggrieved, number 2. AGG is a non-contract word. By an injustice, we know what injustice means, just for us. Done is past tense. To me is future tense. By Gareth Hughes, doing business as, you put the company there, who did abuse his position to his future, my detriment, and in breach of my constitutional and fundamental rights. Nobody has any constitutional rights. Rights don't exist. Persons don't have any rights. It's a fiction. Okay, you don't have any rights. All there is contracts. Okay, and breaches of contract. So this is the illusion. My constitutional and fundamental rights and the rules of natural justice. The only thing that's been breached here is the rules of natural justice. Okay, right. And then you put your allegations down. Right. So I allege the below acts by you are illegal on the face of it. So number 2 is for this particular instance, the guy went home and one of his employees handed him a piece of paper saying those bailiffs had come around and they'd done this, that, and the other, and he was pissed off, he wasn't having it. So your bailiff number 3, I'm reading, your bailiff's apparent claim on my personal property is unacceptable, as well as unlawful, is wrongful execution, okay, and has caused me alarm and distress and fear of loss, okay. So they don't need to cause you alarm and distress and you feel you're going to lose your stuff, right? It implicitly and wrongfully threatens to cost me time and money in defense of my lawfully held property. And then you go on, and the number 4 is to do with DPA. So it's data protection. Your records are inaccurate, i.e. I am not the person liable on any debt that you allege, and you have been duly noticed of your sticky ass error as of the date that you noticed him of error. So this is there's been a preceding agreement in the sense that this guy had already sent him a notice of error. This is not the first time they'd written to him asking for money. So he'd previously written back to him and told him, no, I don't know what you're talking about. I'm not liable for any debt. Please go back to records. But they still persisted. And they came to his house and left a note. And he wasn't having it. So he said, I've given you notice of error on this date. Okay? Now, we're going to go into the statutes, because we know what statutes are acts, and acts is legal fiction. But if you're still in the legal fiction business and you need these acts to maneuver, they're here. So these are the things you're going to be using. I have a whole line of them. You don't have to have all of them. You just choose which one you want. But there's millions, because these acts, it's endless, right? So you're going to go through them pretty quickly, choose which ones you want, if they're useful for you, and carry on. So here we go. So when it comes to dealing with Mr. Bailiff, we're going to go to here, data protection number 1, okay? So what you do with the bailiff is this. When you receive their offer, right? If their offer is unacceptable, you return it to them with a notice of error, okay? And ask him to cease and desist in line with the DPA, Data Protection Act, the processing of your personal data or information in a manner that's causing you distress, because you haven't given them the requisite authority to do that, the written consent, right? Finished. Done, right? So that's section 7 of a breach. And DPA gives you recourse or remedy. I think it's section 13. You're gonna have to look it up. So if you caused damage by these people, then you can claim under DPA section 13 that they should pay you. All right. Now, I believe. Okay, that's fine. Another one is this one. Number 7 is MCA of 1980. When it comes to enforcing this fake and dubious and unenforceable and fraudulent so-called what do they call them, liability order that look like they've been constructed by a 12-year-old. Oh my goodness. Well, they try to enforce this liability orders according to that statute there, section 125A, 125A, subsection B and subsection C, unless they repealed it. However, 5 years ago, it was still valid. I think it still is. It says that when they show up and they're trying to levy your property, they should give you a copy of the liability order, all right, that is valid, and it's been sealed and signed in a certain way. They never have it, right? The rest is to verify. You can go to Black's Law Dictionary and we're gonna go to the quick. Right. So what they're doing is selling inaccurate information pertaining to the name is causing me injury and unwarranted distress. Because when it comes to that particular, to these particular, what do they call them, liability orders, right? The bailiff number 1 has bought the debt, or he alleges to have bought the debt, right? Now when he buys the debt, he cancels it. Who told him to go and buy it? That's his business. You never told him. So that's the end of the debt. If it's been bought, it doesn't exist anymore. It's been cancelled. End of story. Thank you very much, Mr. Bailey, for buying my debt, and goodbye. If you wish to buy my debt, please give me prior notice, okay? And the conditions and the terms are the different terms from the original debt or the original owner. So you need to tell me all this. You can't just make things up, right? There's also something called Office of Fair Trading Debt Collectors Guidelines. So if you need it, there it is. All the sections you need, plus case law. There's more case law. If they try to distrain goods to pay the costs, they cannot do that. You can strike that off the contract. And you don't need to go into it too much. Say, oops, sorry, I'm going to cancel this here, the term of this contract, because you cannot enforce this. You cannot enforce clause or article this of the contract as per Narget v. Nias of 1859. Thank you very much. Boom. Right, so the rest of it is very individual to this guy, because he had put the notice of removal of implied right of access. Once you do this, in fact, that's what you do as soon as you give him notice of error. You give him notice of error, and then you issue that together with the removal of implied right of access, and then you can refer to it. That's a breach. Now once you've given that notice, they become a trespasser if they breach it. Right? This is a bailiff. Number 17. This here. Haha. So what you need to do is to inspect his certificate. Alright? So this is what you ask your bailiff. So when they ask you, tell you, oh, we're going to come on this day, whatever time, and date to collect the goods, you say, oh, that's well and good, Mr. Bailiff man. Okay, you and your buddy can come over. Okay, however, make sure that you bring your certificate, number 1, okay, and also your license to do business, number 2. And you'll never, ever see a bailiff again. So I don't know why people get into it and get emotional with bailiffs. They're just doing a job, okay? They're trying to hustle you. But it's commercial. It's a commercial process, so you cannot get emotional and argue with the bailiff. Tell him, yeah, sure, come over. Make sure you bring your certificate and your permit, because the certificate is issued by the court. So make sure you bring the certificate and identify the court that issued it, so that you can be a bailiff. Yep, it's on demand, but we don't use those words. We don't demand. Okay, but according to their wording, yep. He's meant to producing when demanded. So there you go. So we don't get into whether or not you owe money or you don't owe money. We ask the bailiff, if you come over, make sure you bring your certificate and your license, and also make sure you bring a valid instrument that you try to enforce, and make sure it's got a seal, signature of whoever issued it, like that. If you don't have these things, guess what? I'm going to be making an allegation that you try to defraud me, Mr. Bailiff. You'll never hear from them again. Come on. Right, a debtor can remove the right of implied access by displaying a notice at the entrance. Right? This is somebody called Lord Justice. I am Lord Justice Donaldson. In the case of Lambert v. Roberts, that's 1981, and you can look it up, whatever those things are. It looks like an appeal. Okay, so Knox v. Anderton, 1983, that's a criminal as well, and R v. Leroy Roberts, 2003, that's criminal also. Alright, you see how nice bailiff can be dealt with. You don't need to watch TV to see a man taking it if you don't pay for it. It's an entertainment. I don't believe, why does anybody believe this stuff? And first of all, why do you have a television? I mean, who has a television in 2018? Watching these things, there's so much else than watching a bailiff removing stuff that if you don't pay for it, they're going to take it. There's more. Debtors can also remove implied right of access to property by telling him to leave. That's it. So you're the debtor, presumably. You can also remove the implied right of access to the property by telling him to leave. That's the word. That's quotation. That's Davis v. Leslie Lyle, 39. And that's King's Bench. Ardell v. Wallace, 1964. And this is quotation. The corporation having been told to leave is now under duty, responsibility, its obligation to withdraw, okay, to withdraw from the property with all due reasonable speed, and failure to do so is not therefore acting in the execution of his duty and becomes a trespasser, with any subsequent levy made being invalid, and attracts a liability under a claim for damages. That's Morris v. Beardmore. It's just 1980. Okay. So all you gotta do is listen. Excuse me, are you the bailiff guy? At the door, when he knocks at the door and asks, well, can I see Mr. Johnson? And you ask him, oh, Mr. Johnson, right? Okay, excuse me, are you the bailiff guy? And he says, yes. Right. The debtor here removes the implied right of access to this property. Please leave forthwith. And please leave with all due reasonable speed. You see. Because failure to do so, you'll not be acting in the execution of your duties. You'll become a trespasser. Okay? And any subsequent levy you're trying to make is going to become invalid. It's going to attract liability under a claim for damages, Mr. Bailiff. You ever heard of Morris v. Beardmore, 1980? Oh, thank you. Goodbye. There's another one. Nah. A bailiff rendered trespasser is liable for penalties in tort, and the entry may be in breach of Article 8. So once you've told them, the right of access has been removed, right? What the hell? So you got him on Article 8 also. That's Jokinen v. Finland. So as long as they're still in the European Union, the unknighted ones, you're still valid. You see. And then carried on, you got to put a fee schedule. It's commerce, so you got to put your money thing on it. So should you wish, so this is a pre-action. So if they don't do something, you're going to sue him for a certain amount of money. Please note that you're obliged by law to provide this information upon request or demand. And you now have 3 lousy working days from receipt of this pre-action notice or complaint, say claim, to provide this information unless you choose to accept the offer of remedy below. So every time you put in a complaint or claim, you need to ask for the remedy. You just don't complain for no reason. You complain because you want something. Alright? Alright, so this guy wanted 1790. So should you wish to consider a private settlement with an ex gratia goodwill payment of $1,000, £790 to myself without prejudice, I can confirm that this would be an acceptable remedy for full and final settlement. For Mr. O'Miller was the guy who went to the door and left his name and a card or something. And also this is their chief conman, him, for the torts listed herein. Alright? And ask him to communicate their response to this reasonable offer in the above within the requisite time, above address within the requisite time. After which the offer for private settlement shall be withdrawn, and then we'll take you to court. So you have to pay cost as well. So this exact paperwork is what you're going to file in court with a few modifications here and there. That's 5 pages in already, if we were going to take him to court. But we don't make documents that long anymore. We do it 2 pages. Just take what you need. You don't have to put all of it in there. Make it as quick as possible. So you limit the issues. So the less you put in, the better. Right. For the avoidance of doubt, I hereby notice. Here we go. Issue this formal notice to him, doing business as their company, and thus their location of removal of implied right of access to your property, which is commonly known as, you put your location there. Your attention is also drawn to the clearly printed and clearly posted notice to this effect at the entrance of the property. So the same notice you sent to him, you put up a copy on your window so you can be read by somebody who's outside. Alright? And then put a condition. Now, any further breaches of this notice is going to attract a claim for further damages. It's business. Alright? So that's how you used to construct it. 6 pages of throwdown. And then this notice and all other documents pertaining to this matter can and will be made part of the public record. That's when you sue them, because at this point it's still private. You're still trying to settle with them in private. However, when you go to sue them, you're going to make the matters public. You see. And then it's going to be a different, it's a matter of public interest. The fact that somebody goes around trying to claim a debt that doesn't exist is a matter of public interest. So you're going to put all these documents on the public record by suing them in the public courts, and may be used as admissible evidence in judicial and or administrative proceedings at law or in equity. Judicial, so you're going to sue them in the High Court or the Crown Court, or you're going to sue them in administrative proceedings if it's to do with small debt. You can sue them on the internet. Northampton Business Center, sue them on the internet, administrative. Or you can sue them in the county court, that's administrative. Or if it's big, if it's mortgage business, then you sue them in the chancery. Alright? At law would be their business, statutory, so they'll call it law. Equity would be the business of the chancery, or your own court, or your common law court. You can convene a common law court. You can even invoke the inherent jurisdiction of the court. Every court in the world is common law court. But you need to invoke that, or they're going to presume that you're statutory, and these are special proceedings. They're not ordinary proceedings. They're special proceedings, and they're statutory. So you need to be very precise with this slippery this slippery gentleman in their nice suits. All right. So yes, that's how we do the bailiff. I don't know what else to say, but we don't deal with bailiffs anymore. What we used to do is every time you receive one of their offers, you'd ask them very kindly in one sentence, please remove my personal details from your database. Okay, thank you very much. You can carry on and say, because I don't believe I ever gave you consent. You see? So there you go. I hope that's a good bailiff for you. Straightforward, ABC. Better still, if you want to deal with them, or if they give you a real hard time, then the best book to get, I think it's online still. We got it online. You can buy it from a store. I think Amazon might stock it. It's called the Bailiff's Handbook. So once you have that, then you know how to deal with a bailiff, because that's the handbook. So you're gonna know how far they can go. What their limitations are, and if they mess with you, how to deal with them. Okay, so ladies and gentlemen, you know what's up. You don't get scared by a bailiff, but for the little boys and the little girls, alright, you need to watch the film, and don't be scared. It's a game, it's an act. Okay, so put on your costume, put on your big stomach, put on your costume, your stab-proof and your luminous things, and carry on acting. Right? It's no big deal. And the guy from the television is not going to come to your house if you respond to it in a proper manner. If you ignore him, he's going to come to your house. But however, the one on television is acting. Just so you know. There's no one who's getting evicted for real, or